In March 2022, the ECOWAS Court of Justice delivered a binding judgment ordering Nigeria to stop prosecuting citizens for criticizing public officials online and specifically named Section 24 of the Cybercrimes Act as the instrument being used to do it. On June 22, 2026, Omoyele Sowore was remanded in Kuje Prison under Section 24 of the Cybercrimes Act for criticizing a public official online. Nobody in Nigerian mainstream media has placed those two facts in the same sentence. This is that sentence. The official version of this story is straightforward. A defendant missed a court date, his bail was revoked, he was remanded. Routine judicial process, a legal matter that is working as designed. But there are three things that do not fit that story. First, the specific law being used to prosecute Sowore was ruled unlawful by a court superior to the Federal High Court in matters of human rights in 2022. That ruling has a case number. It is enforceable. It was not repealed. It was not suspended. It exists. Second, the 2024 amendment to that law, which the government called compliance with the ruling, has already been taken back to the ECOWAS Court by SERAP in a suit filed in January 2025, arguing that the new language is equally vague and equally designed to criminalize dissent. Third, a named former Inspector General of Police, Kayode Egbetokun, the man Sowore spent 2 years publicly calling an illegal IGP, is alleged by sources cited in Sahara Reporters to have personally lobbied the current IGP and DSS leadership in the days before June 22nd, pushing specifically for Sowore's remand. Egbetokun holds no office. His personal case against Sowore was struck out in March 2026. He has no prosecutorial authority, and yet, according to those sources, his fingerprints are on every corridor that led to Kuje Prison. The question this video will answer is this: what does it mean when a man who no longer holds power can still direct the machinery of state prosecution? And who inside the system made that possible? When a retired official can activate an active prosecution through informal channels, the prosecution is no longer about the law, it is about the person behind the law. That is not a criminal matter. That is a captured institution. What follows is a detailed document-by-document account of how an activist ends up in Kuje Prison in 2026 for doing exactly what a binding ECOWAS ruling in 2022 said Nigeria could not criminalize. The DSS knows that ruling exists. The court knows it exists. The subject of this investigation is counting on you not knowing it exists. Subscribe now, because what is coming will make that calculation very expensive. In August 2025, Sowore posted on X and Facebook calling President Tinubu a criminal over remarks Tinubu made during a trip to Brazil. The DSS demanded he delete the posts. He refused, citing freedom of speech. In December 2025, he was arraigned before Justice Mohammed Garba Umar of the Federal High Court Abuja on charges of cyber-stalking and criminal defamation. He pled not guilty. In May 2026, Justice Umar rejected his no-case submission, ruling the prosecution had established a prima facie case and ordering Sowore to open his defense. In June, Sowore applied for Umar to recuse himself on grounds of bias. On June 15th, Sowore says he arrived at court for the scheduled sitting and the judge was not there. He filed a formal letter to the registry requesting an adjournment to July or September. On June 16th, the judge returned, the prosecution applied for his bail to be revoked, and Justice Umar signed the order, issuing a bench warrant. On June 22nd, Sowore appeared voluntarily. The recusal application was dismissed. He was remanded in Kuje pending a June 24 hearing on whether the bail revocation should be stayed. That is the surface narrative. Every mainstream outlet has reported it. Here is what they are not asking. Why is this particular prosecution on this particular charge before this particular judge still alive when the Egbetokun cyberbullying case, which used an identical legal instrument against Sowore, collapsed in March 2026, the moment Egbetokun left office? The answer to that question reframes everything. The Egbetokun case was filed by the police. The Tinubu defamation case was filed by the DSS, a separate institution under the presidency. When Egbetokun lost his political protection, his case collapsed within weeks. The DSS case did not collapse, it accelerated. Different institution, different momentum, same target. And this is not the first time this architecture has been used. In 2019, the DSS held Sowore for 45 days after he called for a Revolution Now protest. A court ordered his release. The DSS initially refused to obey. When they did release him, they rearrested him inside the court building. The instrument changes, the method does not. Use the DSS, not the police. Use the courts as a holding mechanism. Prolong, rearrest, redirect. The fact that dismantles the official story is a federal high court judgment delivered on February 20 of this year, 4 months ago. In that ruling, Justice Musa Kakaki held that the Lagos State Commissioner of Police lacked the legal authority to declare Sowore wanted without a valid court warrant and condemned the action as a violation of constitutional rights. That was a federal high court judge telling the same institutional network now holding Sowore in Kuje that what it did to him in Lagos was unlawful. The system filed no appeal. It simply moved the prosecution to a different court. When a system loses a legal battle in one court and immediately escalates the same strategy in another, the strategy is not a prosecution, it is a campaign. Start with the law because everything else flows from it. Section 24 of the Cybercrimes Act, originally enacted in 2015. It criminalized sending messages that were offensive, insulting, or annoying via a computer or network. In 2020, the ECOWAS Court held that provision violated freedom of expression under the African Charter and the International Covenant on Civil and Political Rights. In a 2022 enforcement ruling, case number ECW/CCJ/APP/09/19, the court went further, declaring it arbitrary, vague, and repressive, and ordering Nigeria to stop using it to prosecute criticism of public officials immediately. Not after a legislative amendment, immediately. Nigeria eventually amended Section 24 in February 2024. The new version removed the words offensive, insulting, and annoying, and replaced them with language criminalizing messages sent for the purpose of causing a breakdown of law and order. The government called this compliance. SERAP filed a new ECOWAS suit in January 2025, arguing the new language is equally vague, equally undefined, and equally capable of being weaponized against dissenting speech. What constitutes a breakdown of law and order is not defined anywhere in the Act. It is a determination left entirely to the prosecution. And right now, it is the DSS doing the determining, using that undefined phrase to charge Sowore for calling the President of Nigeria a criminal. The ambiguity in this law is not an accident. It is the function. A precisely defined law would restrict who can be prosecuted. A vague law gives the prosecutor complete discretion. The person who benefits from that discretion is not a legal abstraction. It is whoever controls the DSS. Now, who specifically benefits from Sowore's remand, and in what form? The direct benefit is not institutional, it is electoral. Sowore ran for president in 2019 and in 2023. His African Action Congress has limited structural reach, but his personal brand as a disruptive opposition voice, especially among digitally connected young Nigerians, represents a political cost to any incumbent that compounds as 2027 approaches. Sources cited by Sahara reporters state directly that Egbetokun advised President Tinubu that the only effective way to prevent Sowore from participating in the 2027 election is to have him remanded in prison. The calculation is not a conviction, it is a disqualification by attrition.
a candidate managing a criminal trial, fighting bail revocations, and defending himself in court, has limited capacity to run a presidential campaign. The prosecution does not need to win in court, it only needs to continue. And the timing is deliberate. The bench warrant was issued in June 2026, 18 months before a presidential campaign would typically take shape. Remand in this window serves two functions simultaneously. It attaches the word prison to Sowore's name at the moment when political positioning is beginning, and it locks his energy inside a courtroom rather than on a campaign trail. Look at who has spoken and who has not. Peter Obi condemned the remand carefully. His language was constitutional, not personal. He called it a dangerous regression for democracy. He did not name the DSS. He did not name Egbetokun. The Labour Party has a 2027 interest in Sowore remaining active as a voice that draws voters away from the APC, and so its silence on the deeper mechanisms of this prosecution is itself a position. The northern political establishment has said nothing at all. Civil society condemnation, SERAP, the AAC, former APC spokesman Timmy Frank, has come entirely from outside the traditional power structure. The mainstream political blocs are watching this with a calculation, not a conscience.
Follow the money, and in this case, the money is a passport. Sowore's passport was confiscated as a bail condition when Egbetokun's cyberbullying case was filed in January 2025. It was returned only in March 2026 after that case collapsed. Before it was returned, Sowore was denied a request to travel for an international engagement. The passport is the financial and political instrument of isolation. It limits a presidential candidate's international visibility, his ability to build external solidarity, and his fundraising reach outside Nigeria. The Tinubu defamation case, filed by the DSS in December 2025, 3 months into the Egbetokun case, ensured that the passport control mechanism outlasted the case that originally created it. The Egbetokun case was the frame. The DSS case was the lock. Now, the name that has appeared behind every arrest, every legal maneuver, and every courtroom confrontation connected to Sowore since 2024 is Kayode Egbetokun. He resigned in February 2026. His case was struck out in March. He holds no position, and yet Sahara Reporter's sources say he was working the phones in the days before June 22, reaching out to the current IGP, Tunji Disu, and DSS contacts, pushing for remand. We will come back to exactly what that means and what it tells us about how the institution actually works. When a prosecution migrates from one institutional actor to another without losing momentum, the prosecution is no longer about the alleged offense, it is about the target. But here is what almost nobody has connected yet, and it changes the entire picture. The ECOWAS Court's ruling in 2022 did not merely order Nigeria to repeal Section 24. It ordered Nigerian authorities to stop using it to prosecute criticism of public officials immediately, before any legislative amendment. That order was binding in August 2025 when Sowore called Tinubu a criminal. It was binding in December 2025 when he was arraigned. It is binding today. And Nigeria, as of December 2025, holds 50 unenforced ECOWAS judgments, the highest number of any member state. The ECOWAS Court's own president said publicly that without effective implementation, the promise of human rights protection becomes a mirage. The prosecution of Sowore is not a violation of the spirit of that judgment, it is a direct active breach of its text. What Kuje Prison means for Nigeria goes beyond the political fate of one activist. This case tests a specific constitutional question that Nigerian institutions have never been forced to answer publicly. Does a binding ECOWAS court judgment, enforceable under treaty obligations Nigeria has signed, have any operational effect on the conduct of federal prosecutions? The answer, as of June 22, 2026, is no. And the federal government has made no statement explaining why.
No court has issued a stay of the regional ruling. No legislation has suspended the treaty. The prosecution is simply proceeding as if the judgment does not exist. That is not an institutional failure, it is an institutional decision. The states are watching that decision. Every governor who has faced civil society pressure on rights violations now has a live demonstration of what the federal government's tolerance for regional non-compliance actually looks like. The economic exposure is specific. Nigeria's digital expression economy, online publishers, bloggers, social media commentators, and the commercial infrastructure around open digital discourse operates on a tacit assumption that political commentary is legally protected. The Sowore prosecution, using the phrase breakdown of law and order in the amended Section 24 to charge him for a social media post, dissolves that assumption. Every Nigerian with a significant online following now faces the same undefined exposure. That is not a legal technicality, it is a market signal. The chilling effect on digital speech is the economic effect. There is also a security dimension that is not being discussed. Sowore appeared voluntarily to surrender to a bench warrant. That voluntary appearance, coming to court knowing he would be remanded, bringing what he called his prison bag, is the act of someone who believes the legal system, even a system he is challenging for bias, is worth engaging. When the state responds to voluntary surrender by having DSS operatives physically grab him in the court compound in front of journalists and live streaming phones, according to accounts from his supporters, it sends a specific message to every non-state actor monitoring the boundaries between citizens and the Nigerian state. That message is, surrendering to legal process is not a protection. That is a security communication, regardless of intent.
Now, the thread opened in the power layer about Egbetokun's continued influence needs to be closed because it is the structural key to this entire story. Egbetokun was replaced as IGP in February 2026. His case against Sowore collapsed in March. He holds no official position, yet sources say he was working to secure Sowore's remand from outside his former office, calling the current IGP, calling DSS contacts, pressing for a specific judicial outcome. What this tells us is that Egbetokun retains enough informal authority over people still inside the system, enough active leverage over institutions he no longer formally controls to direct a prosecution from which he has been officially removed. An institution that changes its visible head while keeping its informal networks intact has not been reformed, it has been rebranded. Here is the data point that reframes the national stakes. As of December 2025, Nigeria has 50 unenforced ECOWAS Court judgments. The court's president said so publicly, presenting enforcement statistics at a World Human Rights Day event. Guinea has 0 enforced judgments from 25 cases. Nigeria has 10 enforced out of 125. Nigeria is not an outlier that lacks the resources to comply. Nigeria is an outlier that has made a policy choice not to comply. Across 4 administrations, 2 major parties, and 2 decades of signed treaty obligations. The Sowore prosecution is not an anomaly in that record. It is the record in action. A government that maintains 50 unenforced ECOWAS Court judgments while actively conducting prosecutions that those judgments prohibit has not failed to comply. It has decided that compliance is optional. The difference between those two positions is the difference between institutional incapacity and institutional defiance. The strongest case for the government, stated with every advantage, is this. The rule of law requires that court processes be respected, including a judge's authority to revoke bail when a defendant fails to appear.
Sowore missed a hearing, the court acted within its powers. Furthermore, the 2024 amendment to Section 24 was itself the product of compliance with the ECOWAS ruling. The offending provisions were repealed and replaced by a more specific formulation. Whether the new language is also unconstitutional is a pending legal dispute, not a settled verdict. Until the ECOWAS Court rules on SERAP's 2025 suit, the current law is the operative law. A prosecution under operative law is a lawful prosecution. That argument is technically coherent. It deserves a direct response. The 2022 ECOWAS enforcement order did not say repeal this law before proceeding. It said stop using it now. The enforcement writ signed by the court's registrar is not a legislative instruction. It is an immediate cessation order. That order was in full force in December 2025 when the DSS filed charges against Sowore. A new SERAP challenge to the 2024 amendment does not diminish the 2022 order. It extends the legal argument against the same underlying practice. The government's compliance claim is, we eventually changed the law. The court's order was immediately stop the arrests. Those are not the same instruction, and the government knows it. Now, the data point that does not support this video's thesis and that deserves an honest engagement. Sowore did miss the June 16th hearing. His legal team had withdrawn. He wrote to the court registry requesting an adjournment, but there is a genuine factual dispute about whether that letter was received before the bench warrant was issued. If the registry did not transmit it in time, then the revocation of bail and the issuance of the warrant are procedurally defensible, irrespective of the political context around the prosecution. The case for judicial bias rests on pattern and inference, not on a specific documented act by Justice Umar on a specific date. That is a real limitation. The remand, viewed in procedural isolation and without access to the full court record, cannot be declared unlawful on currently available evidence. But that limitation does not change the overall argument, because the question this video is asking is not whether the remand was procedurally correct on June 22nd. The question is whether the prosecution that generated the remand is lawful, and the ECOWAS ruling of 2022 says in binding legal text that it is not.
One misconception needs to be corrected clearly. The most common misunderstanding about this story is that the ECOWAS ruling was resolved when Nigeria amended Section 24 in 2024. It was not. The amendment addressed the legislative text. It did not constitute full compliance with the enforcement order. Nigeria has not reported complete compliance to the court. SERAP returned to the ECOWAS Court in January 2025, arguing the amendment preserved the same repressive function under new language, and the government is prosecuting Sowore under the amended version of the very provision the court ordered repealed. The amendment is being presented as closure, it is being used as cover. Two positions. Choose one and tell me in the comments which one you hold and why. Position A. The Sowore remand is a lawful procedural response to a defendant who missed a court date, prosecuted under a law that was amended in response to a regional court ruling. Whatever its political context, the process has legal integrity. Position B. A man is in Kuje Prison today on a charge a binding regional court judgment prohibits, prosecuted by an institution allegedly steered by a former official with no remaining authority, under a law whose vagueness has already been challenged in a new ECOWAS suit filed this year. Both positions are defensible. One of them requires you to believe that an ECOWAS enforcement order means nothing in practice. If you hold that belief, say so, because that belief itself is the most important political fact in this story. And if this analysis has shifted what you believe, hit like, not as a favor to this channel, as a signal to the algorithm that Nigerians are demanding analysis that reads the documents, not just the headlines. 3 moves. Watch all 3.
The first and historically consistent pattern in how the Nigerian state handles Sowore is not conviction, it is procedural indefiniteness. The June 24 hearing, scheduled today, will determine whether the stay application on his bail revocation succeeds or fails. If the stay is granted, Sowore walks out of Kuje pending the continuation of trial. If denied, a new date is set and he remains in custody. The government's interest is in the second outcome or in a sequence of technical delays that keep him in procedural limbo through the second half of 2026 and into the early campaign window of 2027. That is the same playbook used in 1919. Slower this time, better dressed, same destination. The second variable is Tunji Disu, the current IGP who replaced Egbetokun in February. Disu has no personal stake in Sowore's prosecution. His appointment was itself a break from Egbetokun's network. The question is whether the informal pressure Egbetokun is alleged to have applied on him, lobbying him to ensure Sowore's arrest, is a genuine ongoing channel of influence or a one-time intervention Disu cooperated with without making a commitment. If the remand produces sustained international condemnation, amnesty, UN special rapporteurs, a US State Department statement, the political cost of maintaining any informal Egbetokun connection rises sharply for a man still in the early months of a new appointment. His institutional loyalty is not yet fixed. That is both a risk and an opportunity in this situation. The third move belongs to the ECOWAS Court itself. SERAP's January 2025 suit, case ECW-CCJ APP 03/2025, challenging the 2024 Cybercrimes Amendment, is now the most consequential pending legal proceeding connected to this case. If the court issues an interim order suspending use of Section 24 while the suit is determined, it creates a direct conflict between a regional court order and an active federal high court prosecution. Nigeria has navigated that conflict before by ignoring the regional order. But each time it does so in a case with this level of domestic and international visibility, the cost of the next non-compliance compounds. Watch for any scheduling notice on that suit. 3 specific signals to watch in the coming weeks. Watch the June 24 hearing outcome. Watch whether Sowore's passport, just returned in March, becomes a bail condition again in this round. Watch whether any member of the National Assembly formally requests a briefing from the DSS on the legal basis of the prosecution under the 2022 ECOWAS ruling. And watch Peter Obi. If his language sharpens, if he names the DSS, names Egbetokun specifically, it will signal a decision to use this case as a 2027 mobilization asset. The moment that happens, the calculation inside Asorok changes.
Now, the question posed at the start of this video. What does it mean when a man who no longer holds office can still direct the machinery of state prosecution, and who made that possible? The answer is in the evidence. Egbetokun holds no authority. His case is dead. His successor was chosen by the same president who authorized his controversial tenure extension. The DSS, which filed the Tinubu defamation case, is an institution under the presidency. It takes direction from the presidency, not from the police. What connects Egbetokun's informal lobbying to the DSS prosecution is not formal authority. It is a shared institutional interest. Both the former IGP and the DSS benefit from the most persistent and loudest public documenter of their conduct being removed from the political arena before 2027. The person who controls both the DSS and the presidency is the same person whose name appears in the social media post that initiated the prosecution. If the trajectory of this case continues unchallenged, if the ECOWAS ruling remains functionally unenforced, and if the amended Section 24 is used to prosecute critics through the 2027 election cycle, and if Sowore's case is not resolved before nominations open, Nigeria arrives at its next presidential election with a legal instrument capable of remanding any candidate on the basis of a social media post,
operated by a security apparatus with no judicial oversight requirement, steered by informal networks that survive official transitions. That is not a warning about Sowore. That is a description of a system capable of determining who is allowed to stand for election. In 5 years, the question is not whether Sowore runs, it is whether the infrastructure that stopped him is still standing and who it is aimed at next. One final question for the comment section, and this analysis cannot resolve. Nigeria's 50 unenforced ECOWAS judgments have accumulated across multiple administrations: PDP, APC, Obasanjo, Yar'Adua, Jonathan, Buhari, Tinubu. The system of non-compliance is bipartisan and structural, not personal to any one government. So, is the solution to what is happening to Sowore inside the Nigerian court system, or has that system already demonstrated across 4 administrations and 2 decades that it cannot be the solution to itself? You now hold information that the majority of Nigerians watching the news tonight do not have. They know Sowore is in Kuje. They do not know that the law used to put him there was ruled unlawful by a binding regional court judgment in 2022, a judgment with a case number, a registrar's writ of execution, and a public enforcement record showing Nigeria has defied it. They do not know that a former Inspector General of Police, who has remaining authority, is alleged to have personally lobbied the current IGP and DSS leadership to secure that remand. And they do not know that the government's compliance claim that it fixed the law in 2024 is itself the subject of a new ECOWAS suit already in progress. That gap between what happened and what the public is being told about what happened is exactly what Naija Unmasked exists to close. There is a Nigerian watching this unfold right now without the full picture. You know who they are. Getting this analysis to them is not a favor to this channel. It is the natural action of someone who now carries information that matters and knows it. The thread this investigation has opened but not yet resolved. The name Victor Adewale Egbetokun, son of the former Inspector General, appeared in a document showing that 100 million naira drawn from an Anambra State security vote account was transferred into a Zenith Bank account bearing his name in September 2025. He holds no public office. He is affiliated with no government agency. That money has no public explanation, and the man whose prosecution of Sowore collapsed weeks after leaving office used to command the institution responsible for investigating exactly that kind of transaction. That thread will be pulled in the next investigation. Until then, this is Naija Unmasked. The mask comes off. I will see you in the next one.